In-kind support was provided by St. Germain Catering. Food for the crew and our guests was provided by St. Germain Catering, a woman-owned business that is professional in every delicious detail. In-kind support was provided by FXA Social Sports, Northern Virginia's largest co-ed men's and women's adult sports league with over 32,000 players, offering flag football, soccer, softball, basketball, dodgeball, and more. In-kind support by the Ruddy Law Firm, located in Fairfax, Virginia. Its attorneys provide legal services in the fields of business, tax, estate planning, probate, guardianship, and conservatorship. Welcome to the Probate Nation. My name is Richard Ruddy, and I will be moderating a Virginia probate series on how to probate an estate in Virginia. Probate is a process to transfer ownership of probate assets to the beneficiaries of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets are delivered to the decedent's beneficiaries or heirs. Some probate trains are short, while other probates seem to never end. The Virginia Probate Series will, in 4 separate programs, discuss the typical probate ride, beginning with how to initiate probate and start your probate train on its journey, what to do and when along the way after you have initiated a probate, how to report properly what you have done to the court, the tax authorities, and the estate beneficiaries while you're on the probate train. And finally, at the end of your trip, how to properly deliver the remaining probate assets to the legal beneficiaries and exit the probate train. We hope with these programs to make a difficult situation a bit less confusing for those who take on the responsibility to probate the estate of a loved one and drive the probate train. In order to start the probate journey, someone needs to be in charge of driving the train. The title conferred on that person is typically executor or administrator, and they may be named in a will or volunteer to serve when there is no will. Regardless, that person is not empowered to drive the probate train until they are appointed to do so, and there are steps that need to be taken to get legally appointed. Today we learn from the expert on how to initiate probate in Fairfax County. With me today is the clerk of the Fairfax County Circuit Court, formerly in private practice in Northern Virginia, concentrating on both residential and commercial real estate transactions. He was elected to the clerk of court position in 1991 and re-elected 2 more times in 1999 and 2007. During the course of his tenure as clerk of court, the volume of filings in the Fairfax Circuit Court has risen in every area, from land records to civil and criminal cases to probate qualifications and more. Please join me in welcoming the Honorable John T. Frey, clerk of the Fairfax County Circuit Court. Welcome, John.
Thank you, Richard.
You've served as a circuit court clerk now for a number of years. How have you seen other states handle probate in comparison to Fairfax County?
Well, Virginia has what I call an administrative probate system, and I think it's one of the best things as far as our court system in Virginia that we do. And that is that in most cases, you're not going to need a lawyer to probate an estate. If the family's not fighting, if everyone gets along, if there's a will, or even if without a will, if it's a relatively simple estate, you're going to be able to come into the clerk's office. My staff's going to be able to walk you through the probate. You're not going to need to go before a judge. And you hear horror stories in other states where it takes years and they have to get lawyers, they have to spend thousands of dollars in attorney's fees, go before a court, and Virginia does it all administratively. If there is a battle between the family members, then it will go to court, but in most cases, 95% plus are handled by the clerk's office only.
That's fantastic. How has the growth of Fairfax County impacted the probate office over these last 2-3 decades?
Well, with the whole office, we've really had to deal with the growth with technology. and we put in what we call a virtual probate system there in the probate office, and it actually won an award from the National Association of County Recorders, Election Officials, and Clerks. And basically, we have everything electronic. We actually start with electronic documents, have the clerk's signature with an electronic signature, and when the parties come in to sign the documents, they actually sign once on a keypad, and as they go through the documents, they just have to click it once and it will put their signature on the documents. And once we're done with the probate, we will then file those in the will book in the land record. So that's done electronically also.
So that all happens almost simultaneously with the people getting qualified at the probate office.
Correct. Once they're qualified, the system will automate it with will booking page and so forth, and then it's almost instantly available for the public to review from our terminals downstairs in land records.
Boy, that's amazing. Some people die with wills and some people die without wills. Can you explain the difference to us?
If you die with a will, it's called dying testate. If you die without a will, it's intestate. And basically what that means is that if you have a will, the government is going to honor your wishes. They're going to let you distribute your assets any way that you see fit. And unless there's some public policy issue or not, we're going to follow that and have it distributed exactly like your will says. On the intestate side, there's public policy issues like children by a prior marriage and so forth. And so if without a will, the state steps in and says how things are going to be distributed.
Okay, so to give us a perspective, how many estates qualified, or how many people qualified to probate an estate in 2014, and how many had wills and didn't have wills?
Okay, we probated 1,651 wills last year. Our probates, we qualified 1,651 people. Of that, 521 were without a will, intestate, and the remainder, about 1,139, were with a will or testate.
Is the aging, with the growth of Fairfax and the aging of the population here, has that had any impact on the probate office?
Yes and no. I mean, as far as every time, as we increase population, it's going to have an effect on your office. We've handled that with the probate, virtual probate system. But also, we're fortunate in that as more people move into Fairfax County, people are also living longer. And so we haven't been totally overwhelmed by the increase in population.
That's good news. Mr. Frey, is there anything further regarding the probate office do you want to share with viewers of the Probate Nation?
Yes, basically I just want everyone to know that when you come into probate, it takes a very special person to be a probate clerk. They're very well trained, they're very well educated, but they also have to have compassion. These folks know that you and your family are going through a very difficult time, and they're there to assist you through this time. And I think that you're going to find that the service that you get there in the probate service from these folks is exceptional, and that they really are going to walk you through this system. They want to help you, and I think in a very trying time, it's going to be a comfort for you.
Mr. Frey, thank you for your commitment to the citizens of Fairfax County, for all you're doing in the probate office, and God bless you and continue good luck with the work at the probate office in the years to come.
Thank you, Richard. It's a pleasure to be with you today.
We now turn our attention to some of the nuts and bolts involved in starting the probate of an estate, beginning with getting appointed to drive the probate train. With me today are two members of the management team at the Fairfax County Circuit Probate Division. Shannon has worked in the probate division for 10 years, beginning as a probate clerk, and then as a manager for 6 years, and for the last 2.5 years as a management analyst of that office. Prior to joining the probate office, she spent 10 years in private practice working as a probate paralegal. Her knowledge and experience continues to guide many families through all stages of probate. Also with us today is the current supervisor of the probate division, Tracy Davison. Tracy has worked in the clerk's office for 27 years, and for the last 17 years has worked as a probate clerk and then the probate division supervisor. Please join me in welcoming Shannon Scott and Tracy Davison of the Fairfax County Probate Division. These professionals will guide us further in the probate process, so let's get into the details. What is probate and why is it necessary?
Probate is It can be thought of as many things. It's the general term used for estate administration when somebody has died administering their estate. In our office, it's the term used to record a will, make sure it's valid before we put it on record, and also if an executor needs to be appointed, for appointing that executor. That can all be umbrellaed under the term probate.
And what are probate assets?
Probate assets are things that are solely in the decedent's name. It can be things like stocks, bonds, bank accounts, vehicles, as well as real estate located both in Fairfax County or within the state of Virginia.
And what are examples of assets that are not probate assets, though?
Assets that are in a trust have a beneficiary other than the estate listed as a beneficiary, or pay on death or transfer on death designees.
So some of those are examples of what we refer to as will substitutes. Is that correct?
Correct.
Okay. What's the difference between a beneficiary and an heir at law?
A beneficiary is a person who's going to inherit under somebody's will, whereas an heir at law is a decedent's closest blood relative. They don't necessarily inherit under somebody's will. They just could be their closest relative at that time that that person passed away.
Very good. Can anyone act on behalf of an estate?
No. In order for an executor or an administrator to begin to assume the duties, they actually need to make an appointment to come into the probate office and be appointed. It's not something that they can just go to a bank, present the will or the death certificate, and be able to act with authority.
So this is what we call getting qualified or qualification. So what do you actually mean then by being qualified or getting qualification? Explain those terminologies.
It means that you've come to the probate office, we have validated the will, we have sworn the person in, and we have declared them that yes, they can act on behalf of the estate.
So how do I begin the probate process in Fairfax County to get properly qualified?
First, you'd call the probate office at 703-246-4153 to schedule an appointment. At that time, we'll also go over a list of things that you need to bring with you to the appointment as well.
Now, how soon, if I called today, can I get an appointment in Fairfax Probate Office?
It's about a week.
Excellent. What should I bring to my appointment to qualify?
You would bring the original will, if there was an original will, any codicils or additions to that will, a certified copy of the death certificate, an estimated value of the assets that were in the decedent's sole name. So any of those assets we mentioned before that are held jointly with someone else, we don't need to know the value of those, but just an estimated value of those solely held properties. A list of the heirs at law, those closest blood relatives, their names, addresses, and ages, valid photo ID, and a way to pay the fees.
Excellent. Where is the probate office located?
We're located in the Fairfax County Courthouse at 4110 Chain Bridge Road. It's in Fairfax City, and we're in Suite 401.
So when I arrive for my appointment, what should I do?
First, you'll be asked to sign in and you'll have a seat, and then the first available probate clerk will call your name and bring you back.
Okay. And what kind of questions may be asked during the probate appointment?
Oh, we'll ask for the value of the solely held assets, who the names and addresses of the heirs at law are, whether or not the decedent was in a nursing home, because that can impact where the probate takes place. We'll look for, want to see photo identification, and we'll of course review the will and the death certificate as well.
Okay. Now, you mentioned that there is a probate tax. Is that the same thing as an estate tax?
No, it is not. Those are very different things. Probate tax is paid to the Department of Taxation in Virginia, and it's basically $1 per thousand for probate assets. It has nothing to do with estate tax.
And that does have to be paid at the time that you qualify.
It does. We cannot issue or declare the person as the personal representative until that tax is paid.
Do most people have to then pay that out of their own pocket and then get reimbursed from the estate after they qualify?
Many times that is the case, yes. Or there'll be a joint account that they will have paid it out of that they held with the decedent, but either way.
But that's pretty common.
Yes.
Can an out-of-state resident, someone who's not a Virginia resident, can they qualify as a personal representative of a Virginia estate?
They can, but they need to bring a Virginia resident with them to the appointment. There are a couple of options. The Virginia resident can either accept service of process, so if the estate were sued, they'd have somebody to be able to sue and bring those papers to somebody in Virginia, or that Virginia resident can co-qualify with the non-resident to waive bonding, surety bonding requirements.
Very good. Now, you mentioned that a Virginia resident would have to be present at the qualification and agree to serve. It's my understanding that the Commissioner of Accounts does require some very specific documents to be signed if they're not present. Can you talk about that a little bit?
Yes, they would have to sign a resident agent form, and not only does the out-of-state fiduciary have to sign it and nominate this person, but the person who's accepting the responsibility has to accept on that piece of paper that they recognize that they are in fact the resident agent for that estate.
Now, previously we were able to talk to Mr. Russ to ask him why this was important, because this is a requirement that he requires in Fairfax. It's not something that's required in other jurisdictions. And here's a clip of what he had to say about that.
You know, it's in most Virginia jurisdictions, the resident agent doesn't have to appear. However, in Fairfax, we do require that the resident agent sign an acknowledgement saying that he's accepting the appointment as the agent for the out-of-state fiduciary. That assures that we're not going to get panicked phone calls when the sheriff is serving pleadings on the resident agent. It gives us comfort that we know that the information that goes to the resident agent is also going to get to the fiduciary, which is ultimately what the purpose of it is. So I think Fairfax has it right in requiring that the resident agent acknowledge and be there for his appointment.
What is a bond, and why is a personal representative bonded?
All of our executors or administrators are bonded. It's a protection to the estate against any type of loss. There's two types of bonds, a personal bond and a surety bond. A personal bond is just a document where the executor or administrator would be liable up to the amount that's set on the bond for any loss that their actions might create. A surety bond involves an insurance company. The estate pays a premium to cover the bond, and it does the same thing. In this case, if the personal representative created a loss, the bonding company would replace those assets to the estate, but then they would follow up and attempt to regain.
So getting a corporate surety bond is not a simple process. If you must be bonded in order to get qualified, it is critically important that you speak in advance with the bonding agent, before your appointment. What are some of the criteria that these bonding companies are looking for in order to get a surety bond?
The bonding company is looking at a lot of different things. They'll typically run a credit check. They'll look at the status of the fiduciary as far as whether or not they're a U.S. citizen or whether they reside in the U.S. or not. Also, they're looking at the amount of the bond and potentially how long that bond might be in place.
A bond, whether personal or with surety, is very important for the beneficiaries of an estate being probated. And we had the opportunity as well to speak with Jack Russ, the Fairfax Commissioner of Accounts, about how bonds protect the beneficiary of an estate. And here's what he shared with us about the importance of bonds, both with surety and without.
Unfortunately, we see from time to time there are occasions when fiduciaries violate the trust the court has placed in them. They may make a mistake in distribution where somebody doesn't get what they're supposed to receive. They may abscond with the funds of the estate. It does happen. And in either case, the people who are entitled to the money are going to get hurt. The fiduciary has a bond that is intended to protect against such injury. It's a promise from the fiduciary to fulfill his fiduciary duty. It's the basis for seeking personal recourse, that's a judgment, against the fiduciary. Now, there are really two types of bonds. The first is a personal bond, and the second is a bond with corporate surety. The fiduciary bond, the one that the executor or administrator signs, is personal. It's the fiduciary is the only one who is responsible if there's an error in the administration. If the fiduciary doesn't have any assets, if the fiduciary is gone and you can't find him, the creditors and heirs of the estate are going to get hurt. The bond's not going to do them much good if it's only a personal bond. A surety bond, it basically requires an insurance company to stand behind the pledge of the fiduciary. And in the event there's a problem, the bonding company will come forward, make the creditor whole, make the beneficiaries whole, and then pursue recourse against the recovery against the fiduciary. It's an important protection for those who are interested in the estate, and it should not be lightly waived.
I agree. What does the applicant receive once they've been qualified? What do they receive to evidence that they are now duly appointed?
What they receive is called a certificate of qualification. It's a piece of paper that states that they are the executor or the administrator of someone's estate. It's got our court seal on it and our signature, and that's what the banks and brokerage firms and other institutions are looking for. It's also known as letters testamentary some places, or letters of administration, but in Virginia we call them certificates of qualification.
What are some of the common problems that you encounter in trying to get someone appointed during that appointment process?
We have problems with the will. Sometimes the will won't have been executed properly. There are issues with the notary not notarizing the document properly. Sometimes the person will have filed for bankruptcy, or they don't know the value of the estate, which makes it impossible for us to determine what the bond should be, and we have to be able to bond them. So those are a few of the issues that we run into commonly.
And of course, you're not allowed to give legal advice to anybody, which sometimes may be necessary in those discussions.
That is for sure.
So once a person gets qualified and receives a certificate of qualification, what are some of the reasons why they might have to come back to your office?
They may come back for additional certificates of qualification, copies of wills, or there are different processes to guarantee that creditors have been located, a rule to show cause against distribution, things like that.
You know, this sounds very, very complicated. Should somebody get a lawyer to help them in this whole process about getting qualified?
I would say 9 times out of 10, you probably do not need a lawyer to go through the probate process. But for those situations where the estate is large, or there are just unforeseen circumstances that the fiduciary doesn't understand how to go forward, we would certainly recommend that they seek counsel and get their advice.
Shannon and Tracy, thank you so much for sharing all this valuable information with us today. I know you have many useful guides and checklists on the Fairfax County Circuit Court website. We encourage anyone who wants more information to take a look at the material on that website. Without a doubt, probate can be complicated and confusing, but Clerk John Frey, Shannon and Tracy, and the entire probate office at the Fairfax County Circuit Court have done a wonderful job of making the qualification process simpler and user-friendly for those who need to probate an estate in Fairfax County. Beginning when you walk through the door of room 401 and are greeted by the front desk receptionist, to when you sign in at the front desk for your appointment, to when you sit down with the probate clerk to start the probate process, to when you leave the probate office with your certificate of qualification in hand. Each step has been organized to make this a pleasant experience. And be sure to check out all the useful guides and forms and checklists they have assembled on the Circuit Court website for your use both before and after you start a probate. This brings us to the conclusion of our show today. Getting qualified in the probate office is just the beginning of your probate journey. So as you take a seat and the probate train pulls out of the station, toot the train horn and congratulate yourself on a job well done. The next stop for the probate train will be a visit with Jack Rust, the Fairfax County Commissioner of Accounts. On behalf of myself and the Probate Nation, thank you for visiting with us today.